Good morning, everyone. I declare open this public hearing of the Joint Standing Committee on Electoral Matters for the inquiry into the 2025 federal election. In accordance with the committee's resolution of 4th of August 2025, this hearing will be broadcast on Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. I remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. I now welcome representatives of the Electoral Commission of South Australia to give evidence today. For the Hansard record, would you please state your full names and the capacity in which you appear before the committee?
Leah McLeay, Acting Electoral Commissioner.
Daniel Moriarty, Manager Compliance.
Thank you very much for your time today. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make an opening statement before we proceed to discussion.
Thank you. I'll just make a very brief opening statement. Firstly, thank you for the invitation to appear. The invitation was originally extended to Electoral Commissioner Mick Sherry, who appeared before this committee in 2022. Mr Sherry is on leave and unable to attend. I was appointed as Deputy Electoral Commissioner to the Electoral Commission of South Australia in January of this year, and I have been acting during Mr Sherry's absence for the past month. I understand that the committee is again interested in hearing about South Australia's misleading advertising legislative provisions and EXA's experience in implementing those provisions and some other aspects of EXA's electoral experience. My personal experience is limited, but I will do my best to answer your questions and provide assistance. And I'm joined today by Dan Moriarty, who will be able to assist in answers to questions as well.
Thank you, Leah, and thank you, Daniel, for your time. I understand you've just gone through an election, and no doubt you'll be very busy closing that off, so really appreciate you spending some time before the committee once again. And you're right, I mean, I'm not speaking on behalf of every member and senator here, but I'm certainly interested in the way in which you administer what I'll refer to as truth in advertising laws. I think you have a different name for it, which is understandable. I guess talk us through, broadly how EXA administers these laws and how they've, or if they've evolved over the time that they've been in place.
Okay, so we receive complaints in respect of misleading advertising pursuant to Section 113 of the Electoral Act. So we require the complainant to provide us with sufficient information to assess the complaint. Sometimes we will need to go back to that complainant to get further information. But we would generally want them to be very specific about the advertising itself and their justification for it fitting within the parameters of Section 113. The approach has then been in EXA to make contact with the publisher and give them an initial and brief right of reply. And that is to ensure that the staff who make decisions and the commissioner who makes decisions have sufficient information upon which to do that. Occasionally we receive, or from time to time we do receive complaints that are very light on detail, and without sufficient detail to commence an investigation, those complaints may be closed off, and the complainant will then be advised that that has been the approach that we have taken. We have a small team managing these complaints, so we have a complaints manager, 2 senior complaints staff and 2 complaints officers. In the first instance, the complaints officers will assess these complaints. If there doesn't look as though it is likely to proceed, or there isn't sufficient information to proceed, a senior complaints officer will review that. If there is a proposal to take action in respect of the complaint, or if the complaint involves one of the parliamentary parties, then they have been referred to the Commissioner for the Commissioner to review.
Okay. Within the process, you mentioned you contact the publisher. Have there been circumstances where you've been unable to contact the publisher?
Certainly when complaints are in respect of things published on social media, it can be challenging to identify the publisher. So there will be times where we haven't been able to identify the publisher and have had to proceed with our assessment of the complaint without an opportunity for them to provide information.
And so what happens, say you make a determination, I'm speaking, if you've got a real example, please let me know, but someone lodges a complaint against an online ad, you attempt to contact the publisher, you deem that it's in breach of the legislation, you make a ruling, the ad's still there.
Yes, so the challenging thing with that, of course, is that the remedies that are immediately available to the Commissioner are to require a retraction or to require the cessation of the publication. Without being able to identify the publisher, that's very difficult. We do have some contacts with social media platforms, and we have developed relationships where they will receive a request from us to have the publication removed, but again, that's up to them at the end of the day to facilitate that.
So you don't have any legislation that you can use to direct the social media companies?
No, so we don't have any powers to direct at all. We have powers the Commissioner can request. If a direction or an order is going to be given, that needs to be given by the Supreme Court.
Okay. Just sort of back to the process, you receive a complaint, you've mentioned you've got a small team. What's the turnaround from generally, on average, receiving a complaint to reaching out to the publisher to making a determination?
I might throw that to Dan in a moment, but sometimes that can be dependent upon the circumstances of it. So if on its face it appears to have the potential to be seriously misleading in the context of the election, and the election is still live, then obviously that would be prioritised over something that may have been received by us at the close of the electoral period. But I'll hand that to Dan.
Thank you, Leah. So we have a service level agreement, which is that we acknowledge all complaints within 2 days, and we are in the high 90% with that.
Okay.
We aim to conclude all complaints within 5 business days, but as the Acting Electoral Commissioner said, if we're going backwards and forwards with publishers, respondents and complainants, that can be extended, as it can be extended if we're going for advice or external advice. Generally, and just to echo what Leah said, if it will affect the outcome of the election, then we will prioritise action over the evidential burden.
And how many complaints did you receive in the last election?
In terms of complaints, we received 323 electoral complaints, and so that does exclude the First Nations Voice to Parliament, which was running at the same time, and service complaints, and of those, 48 related to the misleading or truth in advertising legislation.
Okay.
It was slightly less than the 2022 election, where we received 79 complaints about misleading advertising.
Okay. Is there any flow over between, like, do you get complaints just from unsuspecting individuals, complaining to you about federal advertising during the federal election campaign? Do you get any visibility over that? If you cast your mind back, I mean, you might not, Ms. McLeod.
I wasn't with the Commission at the time, but Dan.
Is it? I guess this might be hard for you to answer, but I'll ask it anyway. Like, do you see a stark difference in the type of advertising, I guess, at a federal election compared to, removing the details about the context and the issues, but in terms of that would potentially fall foul of your laws from a federal perspective compared to the state. Do you have an eye on that? I suppose this.
I've not really taken the opportunity to consider that, and would probably have to review some advertising to form an opinion, which would only be my opinion. So.
Yeah.
So I guess in answer to your first question, we do get complaints which relate to a federal matter. Our policy is we will just refer them to the AEC for investigation. We will acknowledge the complainant's complaint and inform them that that's what has occurred. In terms of, I guess, the type of complaints, we get very few to actually make a decision on that, or to give a good answer on that.
And so when do you stand up this team on? Is it when the election's called? Do you sort of start? Do you recruit in-house? Is it new hires? Like, what's the I guess the administrative burden of this role?
So the team needs to be available to handle complaints from as early as people start effectively campaigning in respect of the election. And I wasn't there at the time, but I do believe we have some temporary staff who were brought in to boost the numbers in the team during that election period. And we also have a local government election later this year, so we will be retaining.
So these laws apply to local government as well, do they?
They do, yes.
Yeah, okay.
Yes.
All right.
So what month did you bring on those additional staff?
That was prior to my commencement, so Dan will have the answer to that.
So just to clarify, the legislation has a number of elements, and one of the elements is it has to affect the outcome of the election. So that is really our test on when we bring staff in. So we have one permanent staff member that deals with complaints as part of our FTA, and then we bring additional one depending how many complaints. So for example, for the state election, we started bringing staff on in the September of last year, and then increased that staff as complaints came in.
Is it difficult to find staff to this role?
So it is an interesting question in terms of you can recruit staff that have complaints experience or have legal experience, but the nuances of the Act are often quite difficult. So I wouldn't say it's difficult to recruit staff, but you have to have a period where staff are inducted or at least get used to the Act and have the ability to cut their teeth, for want of a better word, on the minor offences.
Do you get any external support? Like, I think I read somewhere that some people from Attorney General's...
The Crown Solicitor's Office.
Yeah, how do they get involved?
So the Crown Solicitor's Office is available to provide legal advice to us at any point in time in respect of any matter, but from time to time, and I think initially, and in 2022, it seemed that the Crown Solicitor's Office were consulted much more frequently, but now that we have got a package of advice, so to speak, requirements to consult them have reduced, but they're available to us at any point in time to consult in respect of a specific complaint. And on election day itself, they have staff members who position themselves in X's office so that we can resolve complaints very quickly during that period of time. We've also had prior to this election, and I think in the past as well, had some a staff member from the Attorney General's Legislative Services Division seconded to us part-time in the run-up to the election to provide advice as required.
Okay.
But that didn't occur this time?
Yes, it did. Yes.
And, sorry.
No, go.
You say that they're there on polling day. Are they there for pre-poll as well, or just...
Were they on site for no, they weren't on site, but we did have a person who was seconded who was on site. So the person from Legislative Services who was seconded was on site during our early voting. We had additional representation on polling day, but the Crown Solicitor's Office are always available to us. Okay. Am I correct in that?
Sorry, I was just going to add, so at the close of nominations we do as well, only because it's a very tight I guess, timescale, and we need that advice immediately if a nomination comes in at the 11th hour, so to speak.
You mentioned powers to direct. Well, direction has to come from the Supreme Court.
Yes.
Like, do you feel like you need powers to be able to direct in circumstances without going through court? Like, just noting the tight timelines of elections, you know, if there were a finding to retract something 3 days out before the election, like, is it feasible for the courts to then go and direct someone with, you know, in those 3 days? Like, what are the mechanics of how that works? And
Well,
do you need a bit more flexibility? Yes. Do you feel like you need a bit more flexibility?
When we're dealing with complaints, expediency is critical. So we do not apply the beyond reasonable doubt test. If the Supreme Court, if an application is made to the Supreme Court, then they will apply that test because it is an offence under the legislation. So we're not in a position to investigate in a full way these complaints. We have a process that gathers as much information as we can gather quickly, and then a decision is made and a request is appropriately made in that context. If we were to have a power to make an order or direct, then we may be having to apply a different burden of proof, and that wouldn't be something that EXA would be easily able to manage, given it doesn't have an investigative function or investigative powers.
So the laws, I guess, rely upon the goodwill, for lack of a better word, of the publisher to listen to your request. And
that is generally the experience that EXA has had in respect of this piece of legislation, that generally when a request is made, there may be some toing and froing around the wording of a retraction, but there's, I think there have been very few examples in EXA's history of an outright refusal. Would that be correct, Dan?
Yeah, I think so. There's only one from my memory in the last two to 3 years, so few and far between.
Okay.
And that includes by-elections.
Okay. And is it the publishers, are they generally, I guess, political participants? Are they parties? Are they candidates? Are they, or
Third parties.
are they third parties? Have you seen complaints against third parties recently that I guess don't have that same electoral accountability as political candidates and parties?
Both, but I can't comment on the proportions. So, Dan, are you able to comment on that?
Yeah, so I think the legislation is applicable to all, so applicable to third parties as well. And there has been an increase in third parties. As part of the electoral reforms that came in late last year, third parties are now required to be registered in South Australia. So that gives us a bit more governance, I guess, over some of the third party campaigners and brings them within, I guess, our lens. The issue, as the Electoral Commissioner pointed out, is that we lose control when it comes to social media. So it could be that there's an advertisement that's on social media that's been shared numerous times, and trying to trace that back within a very short time scale is often quite complex.
So yes, social media has changed the field a little bit.
Certainly.
And again, relying upon the goodwill of the social media companies to remove
If we're unable to track down the publisher, then the only option we have at that point in time is to contact the social media companies directly through our connections there and seek their assistance.
Some have said having the Electoral Commission delve into the decision making of what is misleading and what isn't, that undermines that could undermine the trust that people have in an independent body to deliver an election. Has that been the experience of EXA over the decades that this laws been in place?
It's difficult to comment on other people's perceptions to an action we may or may not have taken, but we are mindful that that is a risk that this piece of legislation and its requirement that we administer it brings with it, that there could be a perception of partisanship, and we work hard to ensure that we act fairly and transparently in respect of these complaints to avoid that.
How do you manage that risk of
I think
perceived risk? Yeah.
Yes, so I think that we commenced in the election. As I came in January, as I pointed out. But what was apparent to me is that Exit does and has historically educated parties and candidates on this provision, and has sought, I guess, their assistance and support prior to the election campaign commencing, or at least early in the election campaign. And it has, through those relationships, then been able to, and through those earlier conversations and education, then been able to deal directly with the parties and remind them at the point that a complaint is made of our obligations in administering that legislation, but also their responsibilities in adhering to it. And in terms of the decision making, there's transparency and information provided to both the complainant and the publisher through that process, as much as we reasonably can, given that time is of the essence often.
And do you do that same thing with registered third parties as well, that sort of outreach, education? I would imagine it'd be a lot easier to do with established political parties and candidates. How are you, is it the same approach to new entrants into the political process?
So I guess in terms of third parties, we don't hold necessarily briefing sessions for third parties. Part of that reason was, I guess, we didn't expect as many people to register as third parties for the state election, so it's definitely something we will consider in the future. The important thing is that we take an education view straight off. So if a complaint comes in, we're not going straight to any enforcement or requests. We will contact the person, explain the legislation to that person, and encourage them to comply before then taking any further action. So I guess it's education at the later stage as opposed to at the start.
Okay. One last question from me before we go around the table a bit more. Do you feel the public, or do you have any evidence that the public have lost confidence in XR because of decisions you've made in relation to these truth in advertising laws?
I'm not aware of any evidence to support that.
Okay, thanks. Deputy Chair.
So to what elements of the campaign does it apply? Does it apply to anything that's published across the campaign? How to votes, leaflets, campaign signs, and of course social media and...
Yes, so any form of electoral advertising is captured by the section of the legislation.
Okay. And so when it comes to making a judgment, what are the criteria that you use to make a judgment on, well, I suppose it's triggered by a complaint?
It's triggered by a complaint, and our complaints team just apply faithfully the legislative requirements. So it has to be an advertisement published by any means, so that includes radio or television as well. Then it cannot contain a statement purporting to be a statement of fact that is actually inaccurate and misleading. So we really just apply the test that is set out in section 113, and then the third part of that is whether it is to a material extent. So it may be, there's almost three steps. Firstly, is it an electoral advertisement? Secondly, does it contain a statement purporting to be a statement of fact that is actually inaccurate and misleading? And then thirdly, is it misleading to a material extent? And the team work through those requirements.
So misleading to a material extent means, how's that interpreted?
Well, that might, I believe that some of the considerations might be the audience and how widely this publication may have been received. And I'll just ask Dan if there are other criteria that his team have been applying in that respect.
So
None of these have come to me personally as yet, so I'm a bit reliant on the experience of Dan's team.
So generally what the Electoral Commissioner just said, so it has to affect the outcome of the election. So when we're considering the outcome of the election, we consider a number of different elements. So it'd be the time between the advertisement going live and the election. It'd be the audience that the advertisement has gone out to. So was that a postal drop to 10 houses versus a article in the Advertiser? And then we consider whether a reasonable person would change their vote or their behaviour as a result of that. And that's part of the material test.
Okay. So there's an element of judgment in the whole process in relation to how you actually make the application. So of the 48 that you had at the last election, can you categorise how those ended up being dealt with? Were there any references, for example, out of that process? And I mean, if it goes to a trial, I mean, it's effectively beyond the campaign, isn't it? So how do you manage those sorts of elements of the process, or have you had to manage those elements of?
I think just before Dan answers that, I'll just point out that of the 48 complaints we received for the last state election, only 4 of them were substantiated. So there's a large number of complaints received proportionately that are not substantiated. So Dan, will you perhaps respond to the second part of that question?
Yeah, so I guess in terms of, if I'm understanding your question correctly, how do we apply the evidential test post-election?
Well, no, I mean, did any get referred to the legal process?
To the Supreme Court? No, we.
Yeah. So just going back to the point that you made, you've had 48 complaints at the last election. 4 of those have been or were substantiated, which meant that action needed to be taken by the Advertiser. How has that changed or impacted on the public's perception around truth in advertising? And I'm using that as a term. Is there a perspective that the process is actually changing anything?
Unfortunately, I don't. That's a question we can answer.
I'm asking for an opinion, I know, to a certain extent, which I'm not allowed to do. But it's actually an interesting point in the overall scheme of things, because the whole point of passing the legislation was to respond to concerns from the community about truth in advertising. And whether or not it's viewed as actually having an impact.
There's no doubt that individual complainants will be disappointed if we determine that their claim is unsubstantiated. What broader impact that has on the public perception, we couldn't comment.
Can I just interrupt?
If you must.
Thank you. Being a South Australian, and I've always considered, and this might help my colleagues, that because we've had it for so long, and the consistent players in the political system are well versed in it. There's almost like a cultural piece within our political structures that know it's there. So when you unpack it, it sounds really light touch, which I would say it is. Like, it's not like you go looking for anything, you wait till somebody brings it to you.
Yes.
And so therefore, I think a lot of people would be surprised at the low number of complaints and the low number of substantiations. But I do think that if you were to impose the same system in a different place, you'd have quite a different result, because I think in South Australia we're very culturally indoctrinated into this. We are sticklers.
That's a really good advertisement.
So the
Are you sticklers by nature, or are you sticklers because it's law?
So my
We're a
question off the back
slow-boiled
of Senator Greger's intervention goes to the point that the chair made earlier in respect of third-party players who are relatively new to the process. How has your experience been in that sphere? I mean, we've seen quite a few come in over recent times. You've got Climate 200, TEALS. You've had some ebb and flow in and out over a period of time. Get Up, for example, and some of those third-party organisations who some of whom recognise themselves as being a third-party player, some who who believe they're not. I think that's a polite way to put it. But so how do you manage those sorts of things? Because Climate 200, for example, would say that they're not a third-party player. They're a supporter or funder, but they're not necessarily a third-party player. I mean, are they registered in South Australia as a third party?
So no, to answer your last question, they're not. But I think in terms of South Australia, and to sort of echo the Senator's point, there's a package of legislation. So having the third party register, having the ban or regulation of donation, and then having the truth in advertising is a package. So if we try and isolate just the truth in advertising, then it may not be as effective for third parties. But when you bring the third party register and the other parts of the legislation into play at the same time, then I think that changes the lens and the power of that legislation.
So how is Climate 200 regarded sit within the system in South Australia if they're not registered as a third party? Some of us may have a different opinion to whether or not they are or are not, but how do they, for example, fit within the system when they're clearly a significant player in the system?
So certainly we brief political parties and we brief candidates, and part of that briefing is in respect of the responsibilities under Section 113 and the offences under Section 113. As Dan said earlier, we haven't extended those briefings yet to third parties. Otherwise, our engagement with them is likely to be if they're a complainant or a publisher, and that is, while we are implementing the legislation, it is also an educational opportunity at that point.
They get captured under the donations.
Yeah, well, I mean,
that helps.
it does, and it complicates things further.
Yeah.
And recognising that it's not a simple system, because it is about maintaining the integrity of the electoral system, which doesn't matter whether it's state or federal. It's an important part of what we're all doing. Just in terms of the requirement for third parties to be registered in South Australia, what is the scope of that? What are the definitions there?
So a third party has to incur over $10,000 in political expenditure, or in
Sorry, how much?
$10,000
$10,000
in political expenditure, so in advertising, or intend to incur that amount to then become a third party. So if they become a third party prior to, say, the last polling day, they continue to be a third party until 30 days post the next day election. So once they become a third party, they retain that status and
For the term of the Parliament,
yes,
effectively.
yep.
What about associated entities?
So associated entities are required to be registered, and I guess some of that responsibility is on the parties to ensure that they are.
So $30,000 expenditure.
10,000.
Sorry, 10,000. Oh, okay.
It's important to also mention that your unions are not part of third parties.
So is that the associated entity piece?
They're not part. They're not part of associated entities, but they can become third parties if they spend 10,000.
Okay, so the capture test is effectively an expenditure of or intention to expend $10,000.
That's correct. Yeah.
You mentioned in your answer to a question earlier about a level of activity around close of nominations. What are the issues that arise at that point in time? I mean, what drives that particular point in time activity?
So I guess in terms of nomination, it is a firm cut-off. So if they haven't submitted their application or their nomination by that cut-off and it is a valid nomination, then they can't nominate for that election. So some of the issues we have is they may not have enough nominators, or the form might be incorrectly completed. They may not be on the South Australian electoral roll. So we have to do some checks on the validity of that documentation. And if the cut-off's at midday and they submit it at 11:55, we would then consult the on-site legal team to ensure that we are compliant with that.
Okay, so that's more about a compliance of nomination issue rather than a truth in,
That's right.
or an advertising type of.
And the Crown Solicitor's Office just provide another check and balance in that process.
Okay, so I mean that's a normal integrity of nomination type exercise. Okay, thanks, Chair.
Ms. Graham?
Thank you.
Senator Graham?
Thanks for coming. I think it is interesting the way the idea that maybe we need something else from a national perspective to deal with, minimise, regulate, however you want to term it, truth in political advertising. The balance, obviously, between freedom of speech and opinions versus core kind of dismiss information. Now, you may not want to answer this, but if you were to just kind of blue sky it, and someone says, oh, look, we've looked at your staff, it looks like it's got some legs, how would you design a national system? What elements would you put in there? Noting that this is a blue sky exercise.
I think that if there was consideration of a national system, you would really be, one of the key considerations would be the capacity to administer that system. Because I think, as you rightly pointed out, behaviours in South Australia have been shaped by the fact that this has been in legislation since 1985. If this was to be implemented in a new sphere, and particularly in a national sphere, serious consideration would have to be given to how that was done. The Commissioner has and does play a particular role in this, so that isn't necessarily legislated, it is by choice and convention of the Commissioner. But that can stretch that individual's capacity at a time when there are multiple competing demands for their attention as well. So,
And it has been suggested that it's not the right place for any measure.
I think the other considerations would be that whether it was appropriate to provide expanded powers, and then if there were expanded powers, whether they would appropriately sit with an electoral commission, given the concerns about perception of partisanship. So at the moment, as I said, the Commissioner can make a decision and can request action to be taken in respect of that, but they have no power to direct. So if there was a preference for broader powers, then the next question would be, is that appropriately sitting with the Electoral Commission in its independent role with its primary focus on the delivery of an election, or is that more appropriately sitting somewhere else?
Thank you. I just kind of want to change topics now, and I'm interested in the sort of enfranchisement, like how you see things going in terms of enabling voters, particularly in rural, remote, regional areas. In South Australia, we have a proliferation of very, very small towns, with a lot of distance between it. How do you feel your access, the provision of access to voting is going?
Look, those issues are always challenging. We did, at this last election, invest quite a bit of consideration into accessibility, particularly for people in Australia with disabilities. So 1 in 5 Australians have a disability, and many of those are hidden disabilities. And I'm happy to talk about some of the things that were implemented there to increase participation and accessibility. But in terms of rural and regional locations, that is always challenging. The small towns proved we had some significant staffing challenges at the 2026 election, and it's particularly difficult to get sufficient suitable staff to provide that regional coverage. So that's always going to be a challenge for us.
Yeah, I just want to drill into that a little bit. I'm interested in your sense of what the other sort of consistent barriers are, but obviously staffing is one.
Yes.
Now, the difference, one of the things that has been floated is fixed term elections federally, which as you don't know, we have a period where it can be called, but the actual date is not known. Whereas in most states now, it's fixed, and so there's a fixed date. So for 4 years, you know exactly when the election's going to be called.
That's true.
Does that not make it easier in terms of staffing locations, because you know exactly when you need them and you have that period of time in which to find them, train them, etc.?
It certainly ought to make it easier, but some of the challenges that we have experienced would suggest that just finding suitable staff, temporary election workforce in small towns and small locations is always going to be challenging, even when you can pre-plan and prepare for that. And yet there is an expectation that polling booths will be placed in those locations, and in fact a requirement really that polling booths will be placed in those locations because the ability to travel to another polling booth is significantly reduced. So those challenges still exist even when you know in advance when the election's going to be conducted, because people will say that they're available and then life happens and something occurs, illness, other events, and when you're only offering them effectively a day's work, people will contact you at short notice and say, look, no longer available. So that's a challenge anywhere, but it's a particular challenge in those small town locations, and it's more difficult to get staff there at very short notice from other places as well. So certainly that is an issue. We had some issues that arose during the 2026 election with getting our mobile voting teams out to Aboriginal communities. So there was quite close to the election itself, some significant men's business called in some of those communities, which impacted our ability to, and we had to be fairly flexible, adjust the makeup of our teams, for instance. and change dates at short notice. We did have to charter some flights to get into some areas that were cut off by flooding. So there are definitely challenges that you can plan for, and then some that will occur and that you have to be able to pivot and respond to quickly.
And that those things would consistently come up, I imagine, through
Yes.
elections. We hear them over and over again.
Yes.
Obviously, you can have contingencies for them, but you
Yeah,
don't know what's going to happen. Yeah.
Absolutely.
So I don't think it's a secret that this particular election has thrown up more issues than we've seen in previous state elections. And like I say, in the federal context, when we're looking at what are the recommendations that this committee would provide to strengthen the national system, looking into the state systems, what works, what, go there, don't go there, how can we strengthen the system in general? Why was this particular election so hard in South Australia?
Look, I think that is largely going to be the subject matter for an independent external review. Tom Rogers, who's a very experienced electoral commissioner, will be conducting that review and has already commenced that work. There's no doubt that there was quite a bit of change, some legislative, some internal decision making that was put into effect at this election. But as for the ultimate causes, I guess that really is now subject to the independent review, which EXA will be participating in fully, openly, transparently.
Great, good to hear. So in terms of the strategies that you've employed to increase participation, can you just step us through some of the strategies you've used or programs you've used
Yes.
to engage voters and
So at this election, there was for the first time telephone-assisted voting for people who are vision or motor impaired. And I believe that was on the back of a recommendation from EXA after the 2022 election. That was very successfully conducted. We also did some work with disability agencies in respect of hidden disabilities, in particular the sunflower lanyards for people with hidden disabilities. So we trained officials. We set up 3 low sensory inclusive early voting locations. So they were assessed on things like carpeting, low lighting, reduced window glare, set down areas where people could step out to decompress, etc. And again, those were very successful and well received. We developed a number of EXA TV video explainers, and they were captured fairly broadly via social media, so they were targeting perhaps young voters or people who hadn't attended a polling booth before or were anxious about attending a polling booth, and we tried to offer that sort of clear and accessible information to them about what to expect. 50,000 plus letters, personal letters, were sent to first-time voters by the Electoral Commissioner, again setting out easy to understand information about what to expect when they attended a polling booth and so forth. And we've had some positive feedback from individuals who accessed one or other of those options.
Where do you see the biggest gaps in people's knowledge about voting and turning up to a polling booth and engaging in an election?
Look, I haven't really done any particular assessment in respect of that, but my personal assumption would be that it would be people who have not participated in the process before or have not participated in the process a number of times. Obviously their knowledge and comfort levels would be reduced, but people who perhaps are suffering from anxiety or some other hidden disability Certainly the feedback that we have had from the disability agencies that we've been working with is that they find the process very stressful, have historically opted out of that process because it seems too big an ask. So we worked with them quite closely to see what we could do, and took advice and worked with them during the period prior to the election and right up to the conclusion of the election on how we could make that process more accessible to those people. And given, as I said, that that is one in five Australians. Now, whether they're all impacted in terms of their ability to cast a vote, I couldn't say, but even if a significant proportion of them are, or even
Just a proportion.
even a proportion, that's potentially a large number of voters who might not otherwise participate in the process if particular considerations aren't put into effect.
Civics education or competency in that subject in schools has been declining significantly. And this committee did a report a couple of years ago. Since that time, South Australia has implemented some significant changes in terms of civics education. Are you aware of those changes?
I have a low level of awareness, but what I can say is that EXA does employ full-time a qualified teacher who provides outreach and goes into schools and delivers civics education.
That was going to be my next question: is what do you do? Do you engage with the schools, and how does that work? And is there enough of it? Because I think, you know, we do have a concern about people, not necessarily people with a disability or language barriers or anything like that, but just in general.
Yes.
That understanding of getting involved in the process and the importance of that in terms of the strength of our country into the future. What's the kind of frequency, or what's the program that that you do in schools, and what schools do you get to?
Look, I'm not completely across that program, but I have spoken to the staff member responsible for the delivery of it. She is fully engaged largely in that work, so working with schools, working in the education system. And I believe that she may be delivering to programs to schools and children from year 5 up, and that the programs are targeted to the particular age group. So her attendance and delivery of that program would also, I imagine, increase the school's own capacity to deliver that sort of civics education. But unfortunately, I'm not really across the detail of it.
I wonder if you would take that on notice.
Yes.
And just give us a rundown on what that program does, and what the reach of it is. I spend a lot of time with regional and remote schools, and their capacity to engage in a number of the programs that are available federally is a challenge.
Yes.
So just looking for, I guess we're looking for all the good ideas we can find, and all the, you know, what's working, what's not working, what maybe your staff member would have some sense of where the program could be strengthened or
Absolutely.
improved, or anything along those lines would be really very, very useful.
Absolutely, we'll take that on notice.
And then, you might not want to answer this one either. Postal voting, is it going to be viable in the long term?
Postal voting presents an increasing level of challenge from my preliminary assessments and the feedback that I've had from the team who've been managing that postal voting service for EXA. One, the cost has risen significantly, even between the last 2 state elections. It's a real issue for us going into the local government elections, of course, which are entirely postal voting. And also the ability to get the postal votes out within the legislated timeframes and returned to us within the legislated timeframes. And that is particularly challenging when you talk about overseas postal votes. So I don't have the data for this election yet as to the number of postal votes that were returned from overseas, but I certainly was given a figure which I wouldn't be happy to quote here in this forum, but it was a very small number of overseas postal votes returned in time to be counted at the last state election in 2022.
Because obviously, like, elections are changing. You know, we've tried 3 weeks of pre-poll, which is, you know, let's not do that again.
Not a good idea. In the middle of winter.
Yeah, I'm never going to be warm again. Down to the state election this just gone, which was 1 week, which those of us might think that's a really good idea. But in terms of enfranchising voters, what do you have any views or perspectives or ideas or points to consider around what the structure of pre-poll, postal, phone, that kind of all of the different things that we tweak and we change and we work with, what's the magic pudding of all of those things, or what are the considerations we should be looking at when making those kind of recommendations?
Well, certainly early voting or pre-polling was very popular in South Australia this year, even though the time frame was reduced from 2 weeks to 1 week. There were more people participating in early voting than ever before, and that was likely because the restrictions that had been in place previously were removed, so anybody could access early voting. And
Just everyone on the same page, previously you needed a reason.
You needed a reason to cast your vote early. You needed to be unavailable on polling day. And while that wasn't necessarily difficult to convince the polling staff that there wasn't a high threshold to establish that, I'm sure that all of the people who are diligent rule followers would have not turned up for early voting, and this time they were invited to. So it certainly was popular, and that seems to be a trend nationally and even internationally, that people are welcoming more flexibility around the timing of the casting of their vote. Telephone-assisted voting was implemented for the first time and was very successful in South Australia. It would be worthy of consideration as to whether there were opportunities to expand or extend that and increase the voting accessibility for other groups. One that personally springs to mind would be people who are overseas, just because of the challenge of us in getting those postal votes returned. I believe that that has been proposed by EXA in the past and may be proposed again in the future, that the flexibility that that provides would enhance the accessibility of the voting system.
Great. Thank you. Appreciate it.
Thanks, Chair. If I could drag you back to section 113, please. How does the Commission make its position on complaints clear? Do you publicly disclose receipt of a complaint, closure of a complaint? Or, can you describe that process for me?
Dan, do you want to pick that one up?
So we have a policy of not disclosing complaints. We will, in our reports, identify how many complaints and then subdivide that amongst the, offence groups or the provisions of the legislation. But we generally won't comment on either active complaints or when a complaint's been received.
So do participants often claim victory that, my opponent's lied or whatever through the electoral process? I mean, I'm aware of media releases and things flying around during by-elections. So how do you sort of see that fitting against the Commission saying nothing whilst being the public arbiter of this, but participants saying, yep, the police said they lied.
In preparation for this, actually, I reviewed the Hansard from the appearance of Mick Sherry at the 2022 committee, and that was certainly something that he spoke about in a bit of detail there. That often the decision of the commissioner was immediately publicised by the complaining party. And almost used in some ways as a campaigning tool in and of itself. So certainly that was something that he spoke about in 2022. I imagine that those behaviours haven't necessarily changed in that time.
An A+ for your preparation, Ms McLeod, because that's better than my homework for this hearing, I think. I guess one of the things that's interesting to me is how much, through the history of this legislation, but to the extent you're aware is fine, have complainants pushed this all the way to a court process? Because I'd like to know how much case law now exists about the implementation of the Act.
Certainly there wasn't any applications to the Supreme Court in 2026. I was actually Registrar of the Supreme Court at the 2022 election, and I don't believe any applications were received then either. Prior to that, I couldn't comment here today. There are two ways in which the court might become involved in this process. One is an application, perhaps for an injunction to the Supreme Court at the time or during the election itself. And then the other way that the court may be involved is if an application is subsequently taken to the Court of Disputed Returns on the basis that a publication that was factually incorrect materially affected the outcome of the election. But I'm not aware personally of any applications of that nature either, although I'm not going back into the entire history of this piece of legislation when I say that.
Which I did a little bit. Yeah, that's right. And one of the things that is really interesting to me was the Hannah versus Sibbons case. And I didn't get time, sorry, to try and put this into context as how often this has happened, but effectively it was a case taken to the Supreme Court of South Australia, sitting as the Court of Disputed Returns in 2010, and it related to a claim that someone was soft on crime as I guess a political statement, and the court found that it was a statement of opinion based upon statements of fact recorded in Hansard, i.e. quotes, rather than a statement of fact. So my question is, that's very cute, right? That's a classic legal outcome. Two questions. One, if I walk down the Rundle Mall at the moment and ask people, do you believe everything that you see in political advertising in South Australia, would they say yes? Which points to the efficacy of the laws in my view. But secondly, do you think that the lack of disputation in the most recent elections probably points to the fact that the main players now are really good at targeting their advertising to the loopholes, if you like, in the law? Because I can make anything a statement of opinion based on a statement of fact if I craft my advertising correctly.
I don't think I could comment on that, although Dan may have a comment, but the critical thing with the piece of legislation is that it does have to, it must purport to be a statement of fact. That means that anybody can still, as appropriate in a democracy in a democracy in the nature of Australia's democracy, can express an opinion. So it's not an offence to express your opinion. You have to be purporting to make a statement of fact, and so that is quite a significant distinction. What the basis for that decision is, I'm not sure, but if it is in the expression of opinion, then it is not captured by that legislation.
I think I might just add, even where the cases are grey, for want of a better word, for the statement of fact, we will go to the next test to see whether it is inaccurate and misleading. And quite often what will happen is it will fail at that test or the material test anyway, but we will go that next stage if we're unsure whether it's a statement of fact or a statement of opinion.
So, inaccurate or misleading, that's good, actually. That's where I want to go next. So, if you consider a lot of politics relies on modelling potential policy outcomes, how do you make judgments about the accuracy or otherwise of someone's modelling?
So I guess it's important to make a distinction. It has to be inaccurate and misleading. So it has to fit both tests. It's not just inaccurate or just misleading. And then we will look at whether there are verifiable facts, whether there's anything that's in a report in Parliament, in Hansard, and then base our judgment, I guess, on that.
I mean, the classic one, which is probably topical at the moment, was the 2022 claim about $275 off your power bill. There was Reputex modelling to say that. It was heavily contested. Would that have fallen afoul of the Section 113 legislation if it was applied nationally?
Look, I think that would be difficult for us to comment today, because any assessments we make are on the basis of complaint, providing us with information as to why it's correct, a conversation with the publisher. We wouldn't be in a position to make a decision on that one today.
Yeah, because I mean,
In this
the obvious
forum.
parallel I found was the run-up to the 2018 South Australian election, in which the Liberals were making claims about $300 cost savings associated with an energy policy that they were asked to retract. So I'd be very interested to know the basis, and perhaps on those, if you could provide more information about how the Commission made that decision.
We can certainly look and provide some further information about that particular decision in 2018 state election.
Yeah, just because it would be useful to understand, I guess, in contemplation of any potential expansion or applicability of similar laws federally, given so much of modern politics does rely on this, how the law has been framed and how it's been applied by the Commission in a real jurisdiction rather than a hypothetical one. So, yeah, that would be very, very useful.
The only thing I may add there is that there are three tests, as we've described, or three elements. So a statement can be a statement of fact, and it can be inaccurate and misleading, but it might not fulfil the last test of being to a material extent.
Great. How do you decide what is a material extent in an election?
See, as we spoke about previously, it depends on, I guess, the scope of it, where that advertisement's been, if it's, as I said, a letter drop, whether it's on national radio, whether it's in the advertiser, the context of the actual advertisements. We take a holistic view of that and who it is aimed at. Then I guess you've got the ordinary person, or the pub test side of that, in some respect, that would a person feel and that this will change their voting behaviour. And then we come to a determination on that.
So,
And remembering too that we're not applying the beyond reasonable doubt standard of proof at EPSA. We are just the Commission is just making a decision on the basis of the information that it has available in a generally fairly tight time frame. So.
yeah.
So just with your team, when you make these assessments, you get the complainant and you ask them to provide information. If there's not enough information, you just dismiss it, or you ask them for more.
Not necessarily.
Okay, sorry, I generalised a bit there, but you ask them to provide information. You then go back to the publisher. You ask them to. You give them the opportunity to respond. Does the Electoral Commission themselves, I guess, do their own research, or do you just rely on the complainant and the publisher's information?
So we don't have any particular investigative powers, but the team may look, for instance, if it's published on social media, they may look at the site that that's been published on, perhaps the number of people who have viewed or commented or that particular publication. And that may be part of their considerations. So perhaps if it had been, for instance, if it had been published on a social media platform, we were not aware of it having been published anywhere else, and that seemed to be a very small number of people had actually accessed that or viewed that. That may be a consideration.
So do you verify
But we don't have any investigative powers, so it's a very limited and cursory look at those sorts of things.
So you really just rely on the information provided to you through the process, and that's about it?
Yes, generally.
That's all right. Oh, thanks. Yeah, good question. How do you reconcile that difference between EXA applying, I guess, like a reasonable approach, if I could frame it that way, with the fact that for any participant to push it to the next level, the court will apply such a high bar? Because you mentioned it's a criminal,
yes, it's a criminal
offence, so therefore you go straight from EXA being reasonable to beyond a reasonable doubt, satisfying all three of those tests,
Yes.
which to me would be a very high bar legally, but I'm not a lawyer. So how do you sort of reconcile that in the operation of this? Like, to me, if you've got well-funded political participants, and we have many on the federal stage, some more notable than others, one who's actually quite famously litigious, would you see that, you know, billionaires who are politically interested would drive a truck through this by just saying, I'll see you in court?
I think these are questions probably for the policymakers rather than the legislation administrators, if that is a word. But certainly the tests are very clear in the legislation itself. So at subsection 4 of the section, the Electoral Commissioner just has to be satisfied, and the Electoral Commissioner is operating within a particular environment and particular timeframes, and the test is satisfied. It's very clear in subsection 5, however, that the Supreme Court has to be satisfied beyond reasonable doubt. It does create an offence if at the conclusion of the election process, EXA will determine and does make a decision as to whether they will refer any of the complaints to the Crown Solicitor's Office for potential prosecution. If they are prosecuted and they go to court, then that reasonable doubt test will be applied there as well. So the Supreme Court would apply it in determining whether they were going to make an injunction or direct any behaviours, and the court would again apply that beyond reasonable doubt standard to any criminal prosecutions.
Mm-hmm. And so the enforcement, or not enforcement, the effect, if you like, of EXA making a request to a publisher is obviously going to vary depending on the medium in which the advertisement's made, right? So if there's a letter or letter drop, like a physical or a paper advertisement, something physical, that is the subject of a complaint in which the Commissioner makes would you say a retraction request, or how do you describe it?
Yes, so
Yep. How does that work, given that that's now material that exists and is in the electorate? Does it simply require the publisher not to publish any more of it, or are they in fact required to publish an equivalent bit of material saying something different?
So the Commissioner can request that either the publication ceases or that a retraction is published, or a combination of those. So of the 4 substantiated complaints in the recent election, the action that was taken on one was amend the advertisement. One was a retraction was required, another was retraction and cease publication, and another one, no action because it was finally determined after the election had concluded. So those are the options sort of available to the Commissioner.
And in terms of electoral advertisement, what are the tests applied to delineate that from a social media post or that's not paid advertising? You know what I mean? How do you determine or delineate electoral advertisement?
Yeah, happy for you
So
to answer that.
that's defined in the Act as well, in terms of an electoral advertisement contains electoral material, and material is material that will affect the outcome of an election. So it doesn't have to be paid, unpaid. It doesn't matter what medium it's on. So it can be on social media, printed, or by other means.
And it doesn't even need to be authorised?
So all electoral material has to be authorised.
Right.
So that may be a breach of another
It's a-
section
yeah, if you're
of
running afoul of
legislation,
something else.
in addition to the complaint that it's misleading. If it isn't authorised, then that will also be
Yeah, okay, that's interesting.
a consideration.
Do you, with the rise of non-major party political participants, how do you experience as the Commission participants who are not backed by a big machine in terms of the resources to substantiate a claim or produce evidence and, you know, that sort of thing in a timely way? Is that an issue? Probably, given the nature of your experience.
So I guess the smaller parties or those not backed by funding on the major parties do require some more education and awareness. But generally we find that they are more willing to comply with the legislation because they are smaller than the larger participants.
Okay, thank you. The former South Australian Commissioner Steve Tully, who went on to run the Victorian Commission, has previously said publicly that Section 113 meant, I quote, everyone wanted to complain about everything. Have you found, now that's some time ago, I think it was 2010 now, so have you found that subsided over time? I guess you've given us the numbers for the last 2 elections. Is that down markedly on the elections prior to that?
I believe that the figures that the previous Commissioner gave for the 2018 election to this committee had suggested an increase between 2018 and 2022, and then we've had a drop away again. So I haven't got any earlier figures to indicate what the overall trend might be with me, unfortunately.
Okay, no, that's fine. The other thing is we've seen electoral laws and electoral law reform in the High Court a lot lately. Has EXA considered recently or sought advice recently on whether or not Section 113 would likely survive a challenge today? I understand there was one a long time ago, but predating the Lange and McCloy cases, which settled the, or so-called settled the implied right of political communication. Is that something the Commission's looked at?
Not that I'm aware of, but also may not be something that the Commission would seek particular advice on. We're more likely to seek advice to assist us with the implementation of the legislation. If something was to occur to call into question the legislation, we might think differently, but the answer's no.
Yeah, no, that's fine, thanks. We've also sort of tackled a little bit in the brief time I've been on this committee, the rise of AI and its impacts in elections, particularly through the potential for interference and the like. Is it, I guess, your view that where AI material is published and the publisher is identifiable, you could take action, but that there's still a a potential weakness in our democratic safeguards, if you like, by the fact that unchecked AI or bad actors can still promulgate harmful material at new and increasing rates?
So there certainly is a challenge that we're aware of in terms of identifying whether something is AI or has been created using traditional methods of manipulating images and videos. So that can be challenging. We have legislation requiring that anything that is AI generated has a statement to that effect, but also prohibiting the use of a person's image without their consent in AI. So that prohibits the sort of deep fake scenarios, but there are challenges for an organisation like ours in determining whether this is in fact AI generated or could be some other manipulation or creation of this image. Dan may want to speak a little bit more about that.
I think the only thing I will add, this highlights the importance of having really good relationships with the social media companies, and we also have relationships with the Electoral Integrity Task Force, which members will be the signals directorates. So if there is mis or disinformation campaigns, we are able to feed that back through the committee so that can be looked at on a national scale.
And that's effectively done through, I guess, different avenues to this, though, isn't it?
That's correct, yeah.
Right. Interesting. Last one from me, Chair. And it might be hard, given, but if you were redesigning Section 113, or if you were designing Section 113 today from a blank sort of canvas, is there anything that you'd include to make EXA's life easier in administering this regime?
Really, I think that is probably a question best directed to policy makers. If proposals to amend the section were being considered, I imagine we would be consulted, and we would only participate in that consultation process to the extent that there was an administrative consideration that needed to be taken into account. So
that's the answer I was expecting, but there we go. Thank you very much. Thanks, Chair.
okay.
I'll try and get an answer a different way.
I might just get better at answering the question. You do realise that.
What are the challenges you currently face administering the laws as they are? You mentioned social media.
So yes,
Yeah.
so certainly social media, not being able to determine who the publisher is for the AI specific sections, being able to determine that it is in fact AI created. The challenge of working in the very tight timeframes which we would be expected to work within, and gathering information to allow us to, or allow the Commission to be satisfied that the sections criteria have been met. And then again, I understand that from time to time there has been challenges to the Commissioner's proposed terms of a retraction, and sometimes people have hired counsel and there's been a lot of toing and froing, which again chews up important time. So, yeah.
Has resourcing ever been a challenge for EXA in relation to this aspect? Like, I'm assuming you just get a big bucket of money and you have to manage it. Like, would more staff assist with some of the time pressure challenges that you may face?
I believe we've been adequately resourced for this particular function. So.
Yeah. Okay.
I think I might just add to that, the issue probably isn't staffing, it's institutional knowledge. In terms of, if you think media used to be print, but now it's gone on to electronic social media and artificial intelligence. So keeping up with modern technologies in a small amount of time and recruiting staff with that knowledge and experience may be an issue moving forward.
Okay, and just spell out that issue with the Commissioner's proposed retraction. So could you walk me through a process to get there? You've made a determination that something needs to be retracted. The Commissioner then, drafts a statement on behalf of the publisher?
So the Commissioner sets out the terms. My understanding is that the Commissioner has in the past set out the terms of that retraction and has then had parties wanting to litigate the terms of that retraction.
So, sorry, this is a stupid question. Like, the terms of the retraction would be
the actual wording of the retraction, where it's published, how it's
when
published,
it's published,
and so
how
forth.
it's published.
Yes,
Right.
yes. And then there have been in the past, and again, I believe if you refer back to the Hansard in 2022, he speaks to that. There's been contact by counsel representing one or other of the parties in an attempt to renegotiate the terms, and that has again caused some delay.
Has it caused delay to such an extent that the time frame, I guess, exceeds an election date, or the term? No, you don't know.
I couldn't comment on that.
So a bit of tightening around that. Okay, Mr. Burnell.
Thank you, Chair. Thank you both for presenting today. I'm sorry I was a little bit late this morning, got stuck in traffic on the way in from the northern suburbs. But I just wanted to go to the recent changes around campaigning material at polling booth locations. Have you seen a reduction in antisocial behaviour at polling booths at the 26 election in comparison to previous elections with this new legislation in place?
I know that we only had a few isolated examples of antisocial behaviour at the 2026 election, but unfortunately I can't comment on the trend. So, Dan, are you able to comment on the trend?
I probably can't comment on the trend, but I will say that we have a strong working relationship with South Australian Police and other security contractors. And as with Section 113, we do the information sessions to our candidates and our parties where we will talk about their scrutineers and we will talk about their party workers and rely on them to also police their workers.
Because it seems when we've gone around the country, there's been an escalation at federal polling booths with the amount of material being displayed at pre-poll and polling booths, to the point where that's started to create hostile engagement between political campaigners. Yet, from a South Australian perspective, we don't seem to see, admittedly in non-target held seats, that level of hostile interaction, which is, I wonder if it's somewhat related to the fact that there's a reduction in material here in South Australia.
Yes. Not sure that we can, about drawing the link between the two, but certainly there are prescribed limits to the amount of election material that can be displayed around a polling booth. And my observations of the polling booths that I visited during the election campaign seems to be that there was a level of reasonableness and collaboration amongst the party workers on the display of that material.
I want to touch on staffing challenges. It's been, I think, well reported that there has been challenges around getting the staffing levels right at this election at the state level. Has that been a trend that has been seen by EXA over a longer period of time, where we're struggling to find workers for the execution of state elections or is there work that's been done by the Commission to try and reverse that trend?
It has always been an issue, as is my understanding. So there's always a quite high proportion of people who will withdraw at some point prior to election day their willingness or ability to work. The 2026 election saw a larger than usual number of people do that. My understanding is that this is a trend nationwide, and it is something that a number of commissions are grappling with, that it is challenging to get and secure people for these short-term temporary workforce placements. It's more challenging in remote locations because there's a smaller community and a smaller number of participants in the community willing to and experienced in running polling booths. Certainly was a bigger challenge in 2026 than previously, but it is part of a trend.
So some people would probably suggest that that would be an argument for why we need to expand pre-poll to a longer period of time. If pre-poll was longer, would it make it substantially more difficult to secure staffing, or has there been a differentiation between length of pre-poll compared to staffing levels in the past?
I'm not sure I can give a detailed response to that. Certainly, we did not run as many pre-poll locations, so I think, I remember the figure off the top of my head, 59 in total perhaps, compared to the 680 odd polling booths that we have to staff on election day. The early voting centres, as we call them, we tend to only have one or maybe two per district, which does mean that people have to travel a greater distance to cast their vote, but they have, a longer duration, a longer period of time during which they can do that. It's certainly the high number of people who turned out for early voting certainly does take some of the pressure off the polling booths, but it is that expectation of having them in multiple locations and in close proximity in metropolitan areas to where people live, in the town that you live in regional areas. That does mean a significant workforce has to be engaged and deployed for polling day.
No, thank you. I just wanted to touch on the location of your, probably your pre-poll locations firstly. We've heard evidence across the country so far that accessibility is not being met at the federal level. I'm just wondering, what's the process that EXA goes through to find suitable locations that meet the accessibility requirements of the general voting public? And is that aided by the fact that you have fixed terms, or you feel like it doesn't make much of a difference? But I'm speaking for the northern suburbs, those locations that were picked, I felt were exceptionally better than the options that we had at the federal election, whereby people with disability primarily were closer to, parking was closer, and the ability to make their way in and out of the voting centre was a lot safer than what we had federally.
For the first time at the 2026 election, the responsibility for identifying and securing premises was centralised. Previously, the returning officers had taken some responsibility for the identification of the locations. We do often look to locations that we have used in the past as a starting point, particularly in regional sites. For things like early voting centres, I believe that a number of new locations were identified for the 2026 election. There is a checklist of features that we look for in a polling booth location. One of them is disability parking. Sometimes compromises do have to be made in respect of our ability to find a location that ticks every single thing on that checklist. But we do certainly endeavour to find locations that are central to where people are likely to attend and do meet accessibility requirements. Again, it presents challenges because these are short-term rentals, and you are having to identify locations that are either available, not leased, or if they're used for another purpose, they will make them available to us for the period of time we require them. So there's some challenges with that, which I'm sure every electoral commission does have to attend to.
So you mentioned the use of telephone-assisted voting. Mm-hmm. Is this an area where there's an ability for potential expansion or consideration for expansion around those with mobility restrictions?
So at the moment, the legislation allows us to offer telephone-assisted voting for people who are either vision or motor impaired. Okay. They will make contact with a call centre that we set up specifically for that purpose and advise the call centre of their impairment. And then there is a telephone-assisted voting process which involves 2 separate staff members to manage the integrity of the voting process itself. There is, if the Parliament was inclined to expand that scope, then that's certainly something that EXA could deliver in an expanded way to other groups.
Okay, thank you. Thank you, Chair.
I just want to go back to the social media companies and your interactions with them, particularly in circumstances of not being able to identify the publisher or the I'm not sure if that's the right term, because I'm thinking of the social media companies also in the context of being a publisher as well. Are there any obligations on them as a publisher with respect to Section 113? Or
remember that they're all international
no,
organisations.
I understand that, and so you're relying on goodwill in that sense.
Yes.
For them to act. So in terms of your processes, if you can't find the person who put up the post to manage each side of the equation, are you then left to make a judgment based on the complaint in terms of determining the criteria which was is
Yes.
a statement in fact, or
Yes.
purporting to be factual?
So the Commission could be satisfied without speaking to the publisher that the legislative criteria have been met. This inability to contact the publisher, though, may affect the extent to which we can take any action.
Okay. And so there's no obligation on any I'm going to go back to the way that I was framing it, because I'm thinking about social media platforms alongside what I might look at a newspaper. So you've got which is the old school, let's call it, way of an advertisement in a newspaper, determination. It would come back down to a statement of retraction or something of that nature in that circumstance, versus taking a post down and perhaps making a statement in response.
So if the Commissioner is satisfied that the electoral advertisement meets the, or contains a statement purporting to be a statement of fact, inaccurate, misleading and material, then the Commissioner can request the advertiser to either withdraw the advertisement or to publish a retraction in specified terms. So that really is the extent of powers, for lack of a better word, that the Commissioner has in these circumstances, is to satisfy him or herself that the criteria have been met, and then to make a request. So we're never in a position of being able to direct either the publisher or the social media company. However, as Dan pointed out, we have developed relationships and have connections with social media companies, and we'll leverage those where we think it's appropriate to have something removed.
And a question on a completely different matter, your conversation with Mr Burnell in relation to electoral matter at polling booths. Just for the purposes of the public process, what are the limitations around what is permitted at a polling booth? I mean, some of them at a federal level now are decorated to an extreme degree.
Decorated.
Beautified?
Yeah, plastered. Yes. What are the restrictions that exist at a state level here in South Australia?
So, Dan, do you want to? You've probably got that.
Yeah, see, Section 115 of the Electoral Act sets out what the limitations are. In part, the advertisement can't be in excess of 1 metre, 1 square metre. In terms of the question you're asking, the limitation is set out in the regulations, and off the top of my head, I think it's 12 per candidate. But I'm getting confirmation from your colleague, and we do enforce
12
that. So
pieces of advertising.
So each one, they can only have 12 1 metre square advertisements relating to that candidate.
So generally, these are core flutes that people turn up to polling booths with. So there's a maximum number.
So in that terms, what we would term wrap, bunting.
Unless it's 1 square metre.
We don't bunt.
You don't bunt here in South Australia. Okay.
And we also have restrictions on when those advertisements can go up, as the Electoral Commission was saying, and that changes, I guess, the context in terms of federal, where they tend to be up that whole period, whereas in the South Australian context, it can only be put up immediately before, and it has to be taken down immediately after the hours of polling.
So for the period of pre-poll, whatever we decide that might be, any decoration or adornment or plastering of the booth would have to be done on the day and then removed
that evening.
That's correct.
Okay. And so up to 12 pieces.
Yes.
So I shouldn't get too creative here. Okay. So I was going to ask an opinion, which I'm not allowed to do. You find that satisfactorily manages the level of impact of those things on a particular booth and covers off the variations that there might be to a booth?
So I guess there's a degree of self-policing via complaints, if that makes sense. So if a participant puts up too many advertisements, or if they don't comply with the legislation, we will receive a complaint, and then we will act on that complaint. And for the majority of the complaints, because we want to take immediate action, we will phone the party agent, the party officer, outline the legislation, and particularly within the 2026 election, they would take immediate action and either remove the offending material or give their staff or their party workers some further direction.
Okay, and you've found that relationship by having that conversation through a designated point for each of the parties has appropriately managed
That is definitely the lens or the manner in which we did it at this election, and it was efficient. Instead of contacting individual candidates who may not understand the legislation to the degree that party officer, the agent may, using a single point of contact, outline that legislation. And we also found with some of the participants, they would then push that message out to all of their candidates, which meant that we were getting education wider than that one incident.
Yeah, okay. What about third parties in this context? I mean, how are you finding that? Are they subject to the same regulatory framework?
So they are unable to put up any advertisements at the polling location because they're not candidates in that election. And we didn't have any, I guess, complaints that related to third parties attempting to do that.
What the radius is for that requirement? So how close to a booth can a third party advertise or solicit?
So it's within 6 to 50 metres, so they can't be any closer than 6 metres to the entrance of that polling location. It's important to recognise that may not be the door of the polling location if it's within, say, a compound like a school.
So the determination of what the polling booth is a matter for the booth supervisor?
It's a matter for the returning officer.
Divisional returning officer, okay. So third parties are not permitted to advertise at a polling booth. So Get Up, for example, who couldn't be at a polling booth with electoral material.
That's right.
Okay.
But they could be 51 metres
But
away.
they could be 51 metres away if they decided
could.
that was a good idea.
And then they are then held by the other legislation. For example, you'd be aware of the ban of car flutes, so they wouldn't be able to put those up on any stable poles or public
But
infrastructure.
they could stand and hand out information
Yes,
in
that's
a distance away from the polling booth. Yep.
Okay.
What happens, again, very similar question to the truth in advertising one I had before, and I only ask because this happened at the 2025 election. What happens if you can't contact the publisher of the electoral material? Or I suppose it'd be different here because they're all candidates and they're on the ballot paper, aren't they? So you do have a contact.
So there are provisions in legislation for the polling booth manager to remove
Take it down. Okay, so you've got removal powers in relation to electoral signage,
Yes.
but you don't have removal powers in relation to breaches in truth of advertising.
We have the power to, it really is just to make a request. It's
In
very-
truth in advertising.
In truth in advertising, a request can be made, not a direction.
Okay, but in signage, you can
Remove signage.
remove signage. If there's a 13th sign up, you can go take it down.
50-metre radius, you have capacity to take an action.
And it's important to recognise it is only within that. So anything outside of the 50-metre radius is a matter for the local government.
No, that's
So local councils people would be directed to local councils if they want a core flute in their council area removed and believe it breaches the legislation.
So this election, there was a change from Stobie poles, but people can put them on their private property, on their fence or whatever. Have you had any complaints regarding that or any feedback about that change?
We did have, I think people could also use a core flute if they were polling or campaigning directly in the area, and we did have some questions raised about.
Oh, just on an A-frame or something?
Yes, that's right. So we did have some questions directed to us, but whether they came in as formal complaints, I'm not sure.
Yeah, so we had a number of complaints on both situations. So they can have an A-frame if they're within the vicinity and they're campaigning. But in answer to your question, there were a number of complaints because we did see an increase of people placing these core flutes on their private property. Unfortunately, that's not in the legislation and we can't police that, and they were informed of that or educated to that end.
So there were there's a growth in complaints about people having signs on their private property.
And I think it's more from confusion because obviously the context was a ban on core flutes, when the reality is it's a regulation of core flutes, so we can't regulate or we can't enforce on private property. The only caveat to that is that they're still restricted to the size.
Yeah.
So, okay, I was going to ask, does local government have any restrictions with respect to signage on their properties? For example, I think, and it varies across local government areas in Tassie, but it's about, say, 1.5 square metres. Yours is 1, but they would be restricted to having a sign within a certain period of election day, either side, to a limited size of, and I'll say for the purpose of the conversation, 1.5. Do those sorts of restrictions exist within local government?
I believe they do. I'd have to double check, but generally, in terms of the misleading and the advertisement, it follows through to local.
But that misleading element of it would come back to you, not to local government.
That's correct. So local government's only involved as far as it is removing signage from their infrastructure.
And whatever limitations there might be on private property.
That would come back to us as part of a complaint under the Local Government Election Act.
Okay. Bit wordy, I think, but that I think helps. Thank you.
Just the last 2 questions from me, unless anyone else has any. We've taken a great deal of evidence in regards to intimidating and aggressive behaviour at polling booths at the 2025 election. Was there any evidence of that at your most recent state election?
I believe that SAPOL were asked to attend 4 or 5 polling booth locations. There were no significant incidents. There were no particularly aggressive incidents. I believe one of them involved a person who may have had some mental health issues, kicking cardboard screens over and things in a polling booth. A candidate, an MP in fact, was harassed by a person outside of a polling booth, and I think there were just some other small things. What were the other ones that you're aware of, Dan?
Yeah, I think they're very, very minor in nature. SAPOL have been called, and not necessarily in relation to the election, but just happened to be there at the time.
Okay.
And most of them were in the vicinity of the polling booth, except for the one occasion where the gentleman entered the polling booth and was kicking things.
Okay. Do you have a process of recording complaints received by the polling booth returning officer? Do you have any data that you could share in relation to that? Any complaints from voters on their way in about aggressive, electioneering out the front? Do you have some of that data?
I wonder,
Yep.
you've advised us there were 323 complaints in total, whether you could provide us with a categorisation of that?
There is a breakdown which Dan has kindly put together for this, the purpose of today's meeting. 103 of those were display of electoral advertisements, so the sorts of things that we've just been talking about. 73 were in respect of the publication of advertisements and notices, and that would be about authorisation or failure to authorise. 48, as we have said, were misleading advertising. 10 were in respect of the conduct of officers and scrutineers. 8 were in reference to people canvassing near polling booths. 7 were about how to vote cards. Excuse me. 4 were the advocacy of forms of voting was inconsistent with the Act. So I imagine that's encouraging people to do other than fully cast their preferential vote. 4 were interfering with political liberty. 4 were publishing material to identify persons. 3 were about artificially generated material. 6 in total were about artificially generated material, but they were under 2 different sections. One that is about the requirement to identify it having been artificially generated, and I think the other one is about the fact that a person's image may have been used without their consent, so 3 of each for that. Then there was 3 complaints about, and you might need to explain this one, Dan, candidates not to take part in elections.
So that relates to the polling location and candidates being within that 6 metre or within that polling location.
Yep.
2 were offences relating to ballot papers. 1 was bribery, 1 was cards and polling booth, and 1 was heading to electoral advertisements, the heading of the electoral advertisements. So
about 8, I think you said, whereas in regards to canvassing outside the booths where voters
canvassing
raised a
at the polling
complaint
booths.
with either directly with the EXA or with the returning officer.
Yes.
It's been suggested to us, maybe not an issue with only 8 complaints here, but a code of conduct for canvassers from parties and third parties. Is that something that EXA publish? Do you have anything like a no?
So we provide awareness training to the candidates on the behaviour expected of their party workers. And
Oh, you do? Okay.
we don't. There isn't a code of conduct or I guess an official document as such outside of that briefing.
So what do you have material in regards to sort of that expected behaviour? That is it like a slide, a PowerPoint, or?
Yeah. So we have we give an in-person briefing. We give a briefing via Teams or whatever media, but that's also published on our website, so that's available.
Are you able to
That's
provide?
included as part of
Candidate
the
pack.
entire candidate briefing rather than as a separate.
But more to the candidates, not to the volunteers. So you rely upon the candidates, to then
monitor
communicate
the
that.
behaviour
Okay.
of their volunteers.
Sorry, Chair. If I'm not- Is that compulsory for all candidates?
We can't mandate people's attendance at that, but it's offered to all candidates, and I think the attendance and their participation is high.
Okay. Could you provide the committee a copy of that? That's all right. Of the pack, but particularly in relation to that. But again, you still rely upon the candidates and the parties to then relay that set of expectations to the volunteers. And sort of thinking out loud here, third parties aren't a problem because they're not allowed to canvass within 50 metres. Okay. All right, that's it from me. Any other questions? All right, I will
Thank you.
Thank you.
just read a little statement here that I need to do. Thanks for your attendance today. If you've been asked to provide additional information, would you please forward it to the Secretariat by Friday the 15th of May. You'll be sent a copy of the transcript of your evidence and we'll have an opportunity to request corrections to any transcription errors. Thank you for your time. Again, in what is a very busy period for EXA, we really appreciate you appearing before the committee. Thank you.
Thank you.
Hearing's closed.
Thank you.